Hello, thank you all for allowing me to speak to you virtually today and to my co-authors, Lydia Slobodian, Christina Giardi, Philippe Collet, Pradeep Singh, and Chloe Olson for their collaboration in exploring further the application of rights of nature and legal personhood in the ocean context. This is an incredibly important area for further dialogue and growth for the rights of nature movement for a few reasons. First, rights of nature examples have largely been land-based or for nature as a whole. For example, many specific ecosystem designations are for rivers or forests. And second, most examples of rights of nature practice are at the subnational to the national levels. And as we know, the ocean, on the other hand, is a dynamic and interconnected entity where impacts in national exclusive economic zones impact areas beyond national jurisdiction and vice versa. But the good news is that there is a growing movement for its application to ocean law and policy, or otherwise known as ocean rights, and this is growing globally. And this is also where my focus lies. Approximately 15% of the 400 plus laws, policies, judicial decisions on rights in nature now refer explicitly to the ocean or are specific to marine ecosystems or species. Ocean rights can be framed and is manifesting itself in various ways, ranging from the recognition of specific species or species populations, such as sea turtles, whales, and sharks, to specific ecosystems, including the Rio Doce wave ecosystem in Brazil. And we're even seeing initiatives to recognize the entire ocean itself, for example, through the initiative for a Universal Declaration of Ocean Rights. So in our paper and presentation, we specifically explored how a Universal Declaration of Ocean Rights or similar international ethical norm of global ocean governance may influence decision-making and activities. We explored this in the context of marine protected areas, marine migratory species, and deep seabed mining in areas beyond national jurisdiction. A lot of the analysis and research, and therefore how localized rights of nature examples may be applicable to the ocean context, was largely done through exploring Ecuadorian case law, which is one of the most robust areas where we can actually see implementation of rights in nature and understand specifically what it means in practice when we have rights recognized in the Constitution or as an overarching norm. So first, we explored how a Universal Declaration of Ocean Rights may be seen as a tool or a mechanism to implement obligations under the United Nations Convention on the Law of the Sea, including the obligation to protect and preserve the marine environment. The recent BB&J agreement for the conservation of marine biodiversity beyond areas of national jurisdiction actually notes in its preamble that it is the state's desire to maintain the integrity of ocean ecosystems and conserve the inherent value of biological diversity. So though this is preambular text, such text is to inform the development and implementation of the agreement, including in the context of area-based management tools and environmental impact studies. Therefore, it's critical to understand what are the obligations derived from the respect for and the principle of intrinsic values. This is where the Constitutional Court of Ecuador has been particularly helpful. The court recently affirmed that marine ecosystems have intrinsic value, and therefore they have the right to have their existence and the maintenance and regeneration of their vital cycles, structure, functions, and evolutionary processes to be fully respected. As a result, the full expression and respect for rights of nature or rights of marine ecosystems specifically is one way to actually ensure its intrinsic values are conserved. Further, the respect for intrinsic values has been found to create multiple legal obligations. First, in order to guarantee the ocean's vital cycles, processes, and functions, proactive measures must be adopted. Second, economic activity is allowed. However, these activities are subject to strict regulation or even prohibition if they may lead to the extinction of species, the degradation of habitat, or the permanent alteration of the ocean's vital cycles and processes. In this way, ocean rights can start to help ensure that marine protected areas are strictly protected and enforced. And a third point, diverse values such as intrinsic, relational, and cultural values must be considered in decision-making processes. Moving, for example, cost-benefit analysis away from a predominant focus on short-term financial interests and market-based values toward holistic measures of well-being. And, for example, environmental impact assessments, moving them away from a focus on preventing significant harm toward maintaining and improving ecological integrity. In this way, ocean rights may help see marine protected areas as cost-effective by integrating externalities and non-market values into the balance sheet, therefore increasing their designation and the effective achievement of our 30 by 30 goal. Second, we explore how ocean rights may positively influence the conservation of marine migratory species. The Constitutional Court of Ecuador has recognized that animals with migratory behavior have a right to have their migration routes, and habitats respected and protected. If this principle were, let's say, applied globally to migratory marine species, it would mean that governments must take action to remove barriers to migration, just as the Convention on Migratory Species calls for. This could include phasing out gear like drift nets or long lines that unintentionally catch protected species, and regulating shipping to reduce noise pollution and the risk of ship strikes. Additionally, many rights-based laws specific to species specify that the species or population have a right to a healthy environment. Just as human rights, this is a necessary precondition for the enjoyment of other rights, including the right to freedom of movement and food. In the context of human rights, the right to a healthy environment means that governments have clear responsibilities. They have a duty to protect and fulfill that right. They must protect this right through strong laws, proper enforcement, and oversight. In the context of migratory species like whales, this right may require then regulations to limit land-based pollution and contamination to the marine environment due to the prevalent issue of toxin bioaccumulation, rightfully violating whales' rights to a healthy environment. Our final case study is the application of rights in nature within the growing discourse and ongoing negotiations on deep seabed mining in areas beyond national jurisdiction. First, under rights in nature, the respect for intrinsic values creates an obligation to apply precautionary and restrictive measures when there is risk of serious or reversible damage due to the development of an activity. Additionally, the precautionary principle is to be invoked in instances where there is either a lack of scientific certainty or a lack of knowledge regarding the negative consequences or impacts of an activity. Second, rights of nature has been found to invoke the principle of ecological sustainable development. Under this principle, use of the ocean, and therefore the area, is legitimate if three principles are adhered to: appropriateness, necessity, and proportionality. Following this model, in assessing whether deep seabed mining can commence, all three criteria would need to be met. This means that, first, the intrinsic values of the ocean, as the immaterial conditions that make a good living possible, are respected and protected. Second, the least harmful alternative is the alternative that's employed in practice. And third, any violation of the rights of the ocean must be sufficiently justified in satisfying good living for all. Though deep sea ecosystems remain poorly understood and researched, we do know that there are vulnerable, rare, and endemic species and complex ecological processes that can contribute to climate regulation. These could all be irreversibly damaged by disruptive and invasive mining methods. Deep seabed mining is likely to cause, therefore, irreversible and serious damage to the seabed while providing little benefit to humankind as a whole. As such, it would therefore fail to meet the three criteria for ecologically sustainable development and require precautionary and restrictive action. The Universal Declaration of Ocean Rights can be a powerful catalyst to strengthen marine protection, but there are key challenges and further areas for exploration. First, like the Universal Declaration of Human Rights, its impact will depend on national implementation. States will need to embed rights of nature into domestic law and institutional frameworks to ensure it shapes ocean governance domestically and internationally. Second, realizing these rights means confronting existing anthropocentric norms and defining the relationship of a universal declaration with existing treaties like the United Nations Convention on the Law of the Sea. Lastly, we must be mindful that the concept of rights in general remains rooted in Western legal tradition. To be truly transformative, a declaration must embrace legal pluralism, recognizing indigenous and customary law, and the many ways communities understand and relate to the ocean. However, by articulating common ethical and legal commitments, a universal declaration of ocean rights would establish a global moral compass for how humanity relates to the ocean, shifting from a relationship of exploitation and separateness to reciprocity, partnership, and care. It would promote coherence and accountability across ocean-related laws, policy, and governance systems, as well as across jurisdictional lines. Thank you for the opportunity to share these perspectives today, and I look forward to the discussion.